law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome, everybody. Welcome to the Law of Self-Defense News and Q&A show for Thursday, August 19th, 2021. For those who may not know, I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. That's greatly appreciated. Welcome aboard. Of course, this is the weekly show of the Law of Self-Defense. It's the one piece of open access content we produce each week. You don't need to be a Law of Self-Defense membership to enjoy today's content. We do produce a lot of other content over the course of the week for which you do need to be a member, but we can talk more about that in a moment. And what we talk about here, of course, is use of force law as we find interesting events in the news, as well as questions that are sent in from the law of self-defense community, both members and non-members. And today's shows will be mostly questions. Now, if you'd like to submit a question for our consideration, normally I tell all of you to put your questions in the comments. We normally stream this live, both on the Law of Self-Defense website to our members and on the Law of Self-Defense Facebook page. Unfortunately, it's not clear to me that we're actually streaming on Facebook today. My system says we are, but it doesn't seem to be coming up on my own view of my Facebook page, which is a technology issue that first time this particular one's happened, but there you go. In any case, perhaps it'll come up. I see people populating our Law of Self-Defense live feed of today's show, so that's all to the good. Let's see, to give you an overview of what we'd like to cover today before we jump into the details. In terms of news, there's some interesting news that just came out just today, really, on the Kyle Rittenhouse case. Kyle Rittenhouse, of course, is a young man who was armed with an AR rifle in Kenosha, Wisconsin, when he was attacked with deadly force by three men. He killed two of them, grievously wounded the other, and because of the politics around the situation, he's now been charged with murder and various other crimes. And just in the last day or so, the prosecutor has filed the motion in the case to admit or request the trial court to admit into evidence certain additional pieces of evidence that normally would not be admissible. Well, the first is actually just information the prosecution wants, and that is a list of all the donors to Kyle Rittenhouse's legal defense fund. And then second, the prosecutor wants admitted into evidence a clip of video purportedly taken outside the CVS in which it is claimed you can hear Kyle Rittenhouse saying some provocative things. And of course, the prosecutor wants that admitted as evidence at the trial because he thinks it'll help him convict Rittenhouse. And it's the nature of that video evidence that I think is particularly relevant to all of us in the law of self-defense community, a real cautionary tale for all of us. So that's something we'll dive into in detail. That's really the only news item I plan to cover today. We do have a whole bunch of questions that were sent in by our Platinum members, other members of the Law of Self-Defense community, as well as a few by email. One involves the potential legal liabilities around using a binary trigger on one's personal defensive weapon. For those who don't know, a binary trigger is a trigger that discharges a shot when the trigger is depressed, and then can discharge a second shot when the trigger is released. So the legal implications around using that kind of trigger for self-defense purposes. We have another question that asks for greater clarity, discussion around the concept of curtilage, how that applies in a use of force setting, kind of the limits, the benefits, the risks. Yet another question about quote-unquote self-defense insurance for 19-year-olds. Apparently, it's somewhat difficult for 19-year-olds to obtain quote-unquote self-defense insurance. We'll talk about some of the reasons that might be the case. We have another question sent in via email about what qualifies as the use of deadly force. And this in the context of a gun, but the question is, well, certainly firing a gun at somebody would qualify as a use of deadly force, but what about pointing a gun or drawing a gun to a ready position or putting your hand on a gun in an obvious manner, making the other person aware that you have the gun, even arguably pretending that you have a gun that you don't have? which of those would qualify as a use of deadly force as opposed to arguably a mere threat of deadly force? So we'll talk about that in more detail. There's questions about under what circumstances during a traffic stop a police officer can effectively seize your weapon, unload the weapon, return it to you unloaded, demand that you not touch the weapon even after the stop is over until you get to your destination, and so forth. And this really all involves the privileges of police officers to control the scene during what are technically called Terry stops. That's from an Ohio Supreme Court decision, Terry v. Ohio. So we'll talk about the scope of that, the extent to which police officers are privileged to basically disarm you during, a routine traffic stop. I also have a question here sent in by one of our members that is a semi-complicated scenario about being, he's 69 years old, is the hypothetical. He's sitting in his car. Someone opens the door, drags him out. He grabs his 9mm pistol as he's being dragged out of the car and shoots the aggressor. Is he in trouble for having used deadly force, considering that at the moment he fires the shot, the aggressor is using both hands to pull him out of the vehicle, presumably didn't have a weapon in either hand. So we'll talk about that scenario as well. Now, as always, folks, I caution a few things here before we dive into the details on all this. One is, in self-defense law, there are very rarely absolute answers. This is absolutely legal, no question of a doubt. This is absolutely unlawful, no question of a doubt. It's almost always a matter of degree. How close to lawful are you? How far away from unlawful are you? And of course, it's our goal to be as close to lawful as possible, consistent with the safety of ourselves, our family, and others we have a duty to protect. But there are no guarantees, folks. So most of the answers I can give you on this show, or as an attorney working on your case, involve not this is absolutely what you can do, but this is how to think about the problem and understand where you are likely to fall on that spectrum. So another thing I should mention is we got a number of questions again this week on either gun law or questions about various civil suits that are taking place that really are not use of force civil suits. So one example of this is somebody asked me for an update on the lawsuit that George Zimmerman has brought against various actors who, and I would agree, in my legal opinion, violated Zimmerman's rights in bringing him to trial. I wish George all the best in that lawsuit. I certainly hope he wins. I hope he makes himself filthy rich, compelling these people through the judicial process to compensate him for the wrongs they've committed him. But it's not a use of force case, folks. As you probably know, I followed every minute of his actual use of force trial in real time through the many weeks of that trial, starting from jury selection all the way through. But that was an actual use of force trial. His civil suit is not a use of force case. So I'm unlikely to know more about that case than you will know from just having seen things in the news. The other set of questions I wanted to highlight were gun law questions. Under what circumstances can I carry a gun in this jurisdiction or that jurisdiction, or what kind of ammo, what kind of trigger, what kind of... Folks, we do use of force law here. Under what circumstances are you privileged or not privileged to use force against another person in defense of yourself, defense of others, defense of property? That's only tangentially related to anything to do with weapons law, folks. Use of force law doesn't really care in particular what specific kind of weapon you're doing. It certainly doesn't care at all about licensing requirements or permitting requirements or what kind of ammo you're allowed to use, with rare exceptions where you might have some unusual fact patterns. So we'll talk about, for example, today, this whole binary trigger issue, but we'll talk about it in the context of use of force hypotheticals, not gun law hypotheticals. So if you have gun law questions, you need to talk to a gun law attorney. That's not me. I am a use of force attorney. All right, folks, before we dive into the details, I do, of course, want to thank our sponsor for their ongoing support. And that sponsor is, of course, for today's show, CCW Safe, a provider of legal service memberships. What many people mistakenly call self-defense insurance, CCW Safe, in effect, promises to pay their members' legal expenses if their member is involved in a use of force event. And those expenses start big and get bigger fast, folks. Imagine a case where you were threatened. You displayed your gun to deter the threat. You didn't fire a shot. You didn't hurt anybody. You've checked all the boxes to be charged with aggravated assault with a firearm, typically a 10 to 20-year felony sentence if you're convicted. And in such a case, you'd be looking at a retainer for your lead counsel. This doesn't even include me consulting on your case. Just your lead counsel for $30,000 to $50,000 for pre-trial expense, folks. That doesn't even cover the cost of actually going to trial. If you've killed someone in self-defense and you're facing a manslaughter or murder charge, you're easily looking at $100,000 or $200,000 pre-trial legal expense. So if you don't have that kind of money stuffed in your mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought. And that's as if your life depended on it, because life as you know it depends on it. And that's what CCW Safe offers to do for its members. Now, there are several companies out in the marketplace that offer similar services. I've looked at all of them, as you might imagine, and I found that by far, not even close, by far the best fit for me personally is CCW Safe. I'm a member. My wife, Emily, is a member. There are a number of reasons for that that I won't spend this sponsor blurb going into, but I can assure you they are very carefully considered reasons. Now, the fact that CCW Safe is the best fit for me doesn't necessarily mean they're the best fit for you, but I am very comfortable encouraging you to take a look at what they have to offer so you can make an informed decision. And you can do that by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership with them at that URL, lawofselfdefense.com/CCW Safe. If you use the discount code LOSD10 when you sign up, that's LOSD for Law of Self-Defense and the number 10. Okay, folks, that's all I have for the sponsorship. Let's dive into the meat now of today's content. And the first thing I want to touch upon is our one and only news item for today. Now, those of you who spent any time as a member of the Law of Self-Defense community will have heard me before address my concerns about handing the prosecutor weapons to use against you in court that you don't need to hand them. And this is typically done in the most innocent, humorous of senses. But I'm talking about things like having a "we don't call 911" sign at your front door, or a bumper sticker that says "keep honking, I'm reloading," or a window decal that says "terrorist hunting permit," or a Punisher backplate on the back of your Glock. Or like the police officer from a few years ago who had a dust cover on his AR that said, what was it? "You're effed," something to that effect. Or engraving, "smile, wait for flash" on the crown of your muzzle of your personal defensive weapon. Folks, the reason I don't like these kinds of things is because they arguably go to your state of mind. You're making an effective declaration of how you intend to conduct yourself in the world. Not calling 911, threatening the use of force on a bumper sticker of your car, suggesting in a window decal that you're prepared to use force against someone because of their apparent ethnicity or appearance, having a Punisher backplate on your personal defensive weapon. Folks, think about what the Punisher is. He's a cartoon character, a comic character, who's a vigilante, who uses force explicitly outside the bounds of the law, often deadly force. And now you're proclaiming an affectation of the same kinds of characteristics by putting that on your gun. Your Glock did not come with a Punisher backplate on it. Glock does not supply those from the factory. You put that on the gun, presumably because you're attempting to communicate some kind of affinity with this Punisher character. And these are all proclamations by you, or could be characterized rather easily as proclamations by you, to conduct yourself in alignment with these statements, with the not calling 911. Trespassers will be shot, survivors will be shot again. We may think that's funny when we see those signs, but they can be used against you in court. By used against you in court, I mean referenced by a prosecutor to make you look bad, make your intent and conduct appear unlawful. And you gave the prosecutor those tools to use against you. Those tools, none of them did anything to improve your strategic or tactical ability to defend yourself, your family, or your property. They don't help you win the fight. None of them. They can only hurt you. And you're doing that to yourself. And sometimes people ask me, well, Andrew, can you show me an appellate court decision? Can you show me some case law where this has actually happened, where this has been used against someone in court? And folks, people who ask that question just don't understand how the court system, or particularly the appellate court system, actually works. First of all, the appellate court records reflect an infinitesimal fraction of the criminal trials that occur in this country. There is tons of stuff that occurs every day in trials that are never captured in the appellate court records. So the fact that something doesn't happen during the World Series doesn't mean that it doesn't happen routinely during the 160 or 180 games a year that each team plays in the regular season. Second of all, the common things that happen, the normal accepted things, the not unusual things that happen at the trial level don't go to the appellate courts, because the appellate courts deal with the unusual, the unsettled, the exceptional. A prosecutor's ability to make these kinds of inferences from evidence to a jury, to your detriment, is in no way exceptional or unusual. There's nothing odd about it. It's normal. So again, it would not be the kind of thing that would tend to appear in the appellate court records, because there's nothing unusual about it. And of course, when it happens at the trial level, as I can assure you, it happens all the time, we don't know about it because the trial court records are not captured in any professional legal database like Lexis or Westlaw. It's not easily researched like appellate court records are. So the only people who know about it are the people at the local level, typically only the people actually involved in that case. But now, from the Rittenhouse case, we have an example of this kind of thing happening. Now, I want to say up front, we don't know if any of these claims by the prosecutor are true, but for purposes of our discussion, let's pretend they're true. The prosecutor is attempting to get the trial court to agree to admit into evidence at Kyle Rittenhouse's trial a brief video clip. It's apparently a 29-second video clip. I only heard about this just before today's show, so I wasn't able to locate a copy of the actual clip, or I would share it with all of you. If you happen to have it, folks, and want to send it to me, that would be appreciated. Andrew at lawofselfdefense.com, and I'll reference it in some future show, share it in some future show. But in any case, the 29-second clip is supposed to be of video being taken from a vehicle of the front door of a CVS drugstore. And there's a voice on the video, someone within the vehicle where the video is being taken from. That voice is supposed to be that of Kyle Rittenhouse. And on the video, you can see a number of people enter and leave the CVS store, including, apparently, supposedly, a black man as he jogs out of the store. And then Kyle Rittenhouse is supposed to be overheard saying, "Bro, I wish I had my expletive AR. I'd start shooting rounds at them." Close quote. Now, we don't know if that's actual Kyle Rittenhouse's voice. We don't know the provenance of this video. There's no, at least that I've seen, evidentiary foundation for all of this. And I don't have the actual motion of the prosecutor because, again, I only learned of this shortly before the show went live today. But I will obtain a copy of the motion from the court records shortly. But for our purposes, let's assume this is all true. Let's assume this is Kyle Rittenhouse saying those words. Let's assume that it is a genuine video involving him of that CVS where he's making that statement. Well, now the prosecutor is seeking to submit that into evidence to Kyle's detriment as evidence from which a jury is supposed to be able to infer that Kyle Rittenhouse was ready and willing to use deadly force in a situation where it was completely unjustified. And of course, there's nothing in his video of the CVS that would justify the use of deadly defensive force. And that's what the prosecutor says in his motion to the court. In fact, the news report on this quotes from the motion. I'll share some of those quotes here with you. Quote, and this is the prosecutor speaking. His argument for why this video purportedly of Kyle Rittenhouse, his voice captured of the video of the CVS, this is part of the prosecutor's argument. Quote, quite simply, the defendant saw something, jumped to a conclusion based on exactly zero facts, and then threatened to kill someone based on his baseless assumption and wrongful interpretation. The defendant's understanding of the proper use of his AR and of deadly force is crucial to this case, meaning Rittenhouse's use of force in Kenosha. And this video demonstrates that the defendant was eager to use deadly force in an unlawful situation. The video also demonstrates that the defendant, Rittenhouse, fervently sought to insert himself as an armed vigilante into situations that had nothing to do with him. Finally, and perhaps most importantly, the video proves that the defendant was ready and willing to use deadly force in a situation where it was completely unjustified. Close quote. Folks, that's exactly the argument a prosecutor is going to make if you have that Punisher backplate on your Glock, if you have that "We don't call 911" sign on your front door, if you have that "Trespassers will be shot, survivors will be shot again" sign on your property line, if you have that "Keep honking, we're reloading" bumper sticker on your car. Folks, please don't do any of those things. Those are all things that arguably go to your state of mind. That state of mind being an unlawful state of mind, a willingness, an intent to use force outside the boundaries of the law. You're giving that to the prosecutor for no return benefit. So please, I encourage you not to do that. And we have an example of that now from the Kyle Rittenhouse case, unfortunately. Okay, that's the one news item I wanted to share. Let's dive now into... take a quick look at Facebook here and see if anything's changed in terms of the live streaming. It doesn't look like it, folks. So my apologies for that. But all I can say is if you were a Law of Self-Defense member, you'd be enjoying the show live right now on your Law of Self-Defense membership page. And speaking of Law of Self-Defense membership, the good news about it is it's dirt cheap. It's only about $0.25 a day to be a Law of Self-Defense member. And you can try it out for 2 weeks for just 99 cents, folks. That's 2 weeks for just 99 cents. And if you don't like it in that 2-week period, just cancel. We'll give you 200% of your money back. So it's a negative risk opportunity. If you decide to stay a member, as I said, the normal cost is only about 25 cents a day to get near daily use of force law expertise, including this show streamed to the membership dashboard. So we're not reliant on Facebook to get you access. And you can try it out for just 99 cents. You can take advantage of that opportunity at lawofselfdefense.com/trial. And folks, honestly, if 99 cents is too great an expense to better position yourself to lawfully defend yourself, your family, and your property, I'm not sure what to add to that. But that's the opportunity. Trial membership, 2 weeks, 99 cents. Try it out. And by the way, during that 2 weeks, you have complete access to everything you would have as a full paying member. There's no limitation. Hundreds and hundreds of blog posts and hours of video and podcast content accessible to you, just as if you had been a longstanding Law of Self-Defense member for that 2-week trial. Okay, let's jump now into the questions that came in. Whoops. Sorry about that. Let's try this again. And the first is asked about this binary trigger. Let me take a sip. Now, this question was sent in anonymously, so I'll treat it as an anonymous response. But he's asking about this binary trigger. So he has a firearm. And in terms of gun law, folks, I have no idea if binary triggers are lawful or not. I personally don't have any weapons that make use of a binary trigger. I've never researched it. For purposes of this discussion, we'll presume, at least initially, that these triggers are not NFA items, that they're lawful in whatever jurisdiction people might be. But for gun law expertise, again, I refer you to a gun law expert. But for initial purposes, let's assume these binary triggers are perfectly lawful in normal use. And the way they work, again, is they fire the weapon once when you depress the trigger, and then the weapon fires a second time when you release the trigger. And the idea, I suppose, is to get a higher rate of fire than if the return stroke was simply resetting the firing mechanism, and you only got a shot when the trigger was depressed and not also a second shot when the trigger was released. And he's asking, basically, what's the effect on this for self-defense? If I use a weapon equipped with a binary trigger in self-defense, can this be used against me in court? And whenever people ask that, folks, it's important to keep in mind that what we mean by that, can this be used against me in court, is not really, is this going to decisively convict me? If we're presuming binary triggers are lawful, well, then you're not going to prison for having a binary trigger. The question is, does it somehow taint your use of force in defending yourself, your family, whatever the scenario was when you use the weapon with this binary trigger? Can the prosecutor use this against me in court? Means, can he speak about this in front of the jury in a way to make you look bad and make it more likely that he'll obtain a guilty verdict from the jury on whatever the use of force criminal charge against you is, whether it's murder or manslaughter, or aggravated battery, aggravated assault, whatever the case may be. And the truth is, prosecutors can talk about almost anything in a rhetorical fashion. There's almost unlimited things they can talk about if they have any evidentiary foundation at all, particularly during opening and closing statements. That they don't need to be true or realistic or have much evidentiary basis at all, especially during opening and closing statements. So if you use a weapon with a binary trigger to defend yourself and end up criminally charged, you should be fully prepared for a prosecutor to argue to the jury that your use of that unusual hyper rate of fire trigger suggests something wrong with you, suggests a certain animus, something other than a solely lawful interest in defending yourself against criminal attack. Yes, you should expect the prosecutor to do that. Now, how likely is that to actually have a negative impact on your case, on your claim of self-defense? Well, if you have an otherwise robust claim of self-defense, you're sound on all the required elements of your self-defense claim, this kind of rhetorical attack that doesn't actually have a basis in the law, because as we're presuming the binary trigger is not in fact unlawful, if your use of force was otherwise within the legal boundaries of lawful self-defense, then the binary trigger really doesn't matter. Where you run a risk of this rhetorical argument really damaging you is, one, either your narrative of self-defense is not robust, it's marginal, you did things that arguably are not completely consistent with lawful self-defense, and then this rhetorical argument might be just enough to tip a jury over the edge, or you're in a politically charged defense, politically charged use of force trial, and the jury might be looking for anything on which to hang a guilty verdict, either on the charge that you originally dragged you into court or some lesser included offense, some compromise guilty verdict that they want to agree on, just so they don't have to leave jury duty, where all their names will ultimately be disclosed and be the people who found not guilty a defendant who's been characterized for a year or 2 years as a racist or a Nazi, or however this politically charged trial ended up characterizing you. So it can provide traction to a jury that may not really believe you're guilty of anything, but may be unwilling to take the political heat of completing their jury duty, going back into public life where they'll be publicly known as having acquitted you entirely. The question I would ask then is, all right, well, if that's the risk, the legal risk, that the door you're opening by using this binary trigger, what's the offsetting benefit that you're getting? Does a binary trigger really better help you defend yourself, defend your family? I would suggest the answer to that is almost certainly no. I've never used a binary trigger, but I've done a lot of shooting in my life, a lot of high-level competitive shooting. I know a little bit about what it takes to fire rapid, accurate shots under stress, competition stress, of course, not life-threatening stress. And I simply don't believe that having a second shot discharged from the gun when the trigger's released is actually going to be all that helpful. It's very difficult for me to imagine a scenario in which that would be substantively helpful to you winning the physical fight. And if it's not helping you win the physical fight, not improving your odds of winning the physical fight, why incur the legal risk? Why not just have a decent quality, normal trigger on your defensive weapons so that you don't open this door to the prosecutor? Don't give him additional tools to use against you when there's no offsetting benefit. Now, another problem that could arise, besides this rhetorical use of this attack by the prosecutor, is if, contrary to our presumption so far, we've been presuming the binary trigger itself is lawful, but what if it's not lawful? And again, I'm not trying to say it's not, folks. I'm not a gun law expert, but if we were to imagine it's not lawful, or there were some other modification we're talking about that might be deemed to be not lawful, might be deemed to turn your gun into a machine gun, let's say, all right, consistent with this theme of the binary trigger, this higher rate of fire, such that the prosecutor could argue that you've actually committed some underlying felony by this modification to the weapon, or by using a weapon of this particular nature. Well, in most states, simply having also been engaged in the commission of some felony generally will not lose you self-defense, but in other states it will. Some states do condition self-defense on not being engaged in a felony at the time you used force in purported self-defense. And normally, this kind of statutory language is intended to exclude from self-defense people who are committing an armed robbery, for example. You're robbing a convenience store. The clerk pulls his own gun. You shoot the clerk dead. They don't want you to be able to attempt to justify your shooting of the clerk as self-defense, even though in a technical sense, of course, you were defending yourself against the clerk. But the public policy is that you don't get the benefit of trying to justify your use of force as self-defense because you were engaged in a felony at the time. But what if the felony underlying was not explicitly related to the use of force? What if it was drunk driving at the time? What if it was writing a bad check at the time? Well, arguably, you ought not lose self-defense if the underlying felony, and we have a lot of felonies in modern society, folks, didn't really have anything to do with the use of force itself. But of course, if you use a gun with a binary trigger as your use of force, well, then the binary trigger really is causally related to that particular use of force. And if the binary trigger were deemed to be unlawful, whether at the federal level or in a particular blue state, and I've lived in blue states, I know how crazy their gun laws are. It wouldn't surprise me in the least if Massachusetts or New York or Maryland, one of those states, New Jersey, had laws on the books that ban binary triggers. I don't know that they do, but it wouldn't surprise me in the least. And most of their gun laws are felonies. Then if you were committing that underlying felony, you could lose self-defense, not on the merits of your use of force, but because of the possession or use of that binary trigger. So that would be the other risk with using something that's somewhat unusual. And folks, I really strongly encourage you, for your fun guns, for your competition guns, for your plinking guns, I don't really care what you do with any of those. Have fun, make all the changes you want. But for guns you intend for serious social purposes, please use as plain and ordinary guns as you can. Very difficult to go wrong from a legal perspective with OEM Glock 17 pistol, Glock 19 pistol. Okay, I carry a SIG 320, stock normal SIG 320. Don't get fancy or unusual with your guns. The fancier and more unusual you get with your guns, the more you open the door to these kinds of rhetorical arguments by a prosecutor. Be boring. Don't be interesting. Don't attract attention you don't need to. Okay, a second question we received is from Fred. That's not Fred's actual name, but he has an unusual first name. So for purposes of ensuring anonymity, I'll just call him Fred. And he asked about curtilage. He really wants greater clarity on this concept of curtilage in the context of use of force law. Now, unfortunately, it's difficult to provide a high degree of clarity on this legal doctrine of curtilage in the context of use of force law, because the law itself does not provide much clarity. Now, curtilage is a legal concept that applies to the area immediately around your home that's part of the normal day-to-day use of your home. And it typically includes a front porch and a back porch and maybe your front yard and backyard, maybe an attached tool shed, maybe a detached garage, if those things are part of the normal day-to-day use of your home. The trouble is it's a very ambiguous concept. There's no absolute black line where the law says, all right, up to 25 yards from your house, you're within your curtilage, and 1 foot over that, you're no longer in your curtilage. We don't have absolute markers like that. What we do know for sure, one absolute marker is once you're in an area where you no longer have right of exclusion, so you hit a public sidewalk or you hit a public street, or you're in a hotel and you hit the common hallway, the corridor outside the room, once you're in a place where you no longer have right of exclusion, you're definitely not in your curtilage anymore. But within that zone, it's unclear. If you live on a 40-acre farm, that 40th acre is almost certainly not part of your curtilage. It's simply too far removed from the dwelling. The closer you are to the home physically, the closer you are to the home in terms of this concept of part of the normal day-to-day use of your home, the more likely you'll be deemed to have been within your curtilage. But these decisions are made on a case-by-case basis, and they can vary a lot, folks. You could have 2 tool sheds on your property, both in equal distance from your home, say 25 feet from your home. And one of them is where you store your lawnmower and your lawn chairs and stuff that you use, your barbecue, things you use all the time. You're in that shed a few times a week, part of the normal day-to-day use of your home. The other shed is where your granddad put his Ford Model T 80 years ago and no one's gone in there since. One of them is arguably within your curtilage and the other is not, because you don't actually use the other one on a day-to-day basis. So you can see how ambiguous and subjective this scope of curtilage is. And it's even worse because curtilage is one of those legal terms of art that means different things in different contexts. And most of the law on the concept of curtilage has nothing to do with use of force law. Most of it is Fourth Amendment law, search and seizure law. So this comes up because the law enforcement wants to seize evidence, seize a piece of property from around your home. And clearly, if they're going to go into your home to seize property, they need a warrant. Under normal circumstances, a search warrant, they have to go to a judge or a magistrate to blah, 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 do all of that. But what about if the item they want to seize is not in your home? What if it's outside your home? Well, then the law says they need to have a warrant if what they want to seize is within the curtilage of your home. So is it on your front porch? Is it in... alternatively, is it in a garbage can out on the street? Well, the garbage can, you've given up that property. It's outside your curtilage. It's in a place where you don't have right of exclusion. They don't need a search warrant to seize property from your garbage pail. But if it's on your front porch, arguably they do, because arguably the front porch is within your curtilage. But how curtilage is defined, the scope of curtilage, even within a given jurisdiction, a given state, how broad curtilage is for Fourth Amendment law purposes, for search and seizure law purposes, for when an officer needs a warrant to seize that item lawfully. That's a completely different scope of curtilage than the definition of curtilage for use of force law purposes. They're not the same thing. So when you research curtilage in your jurisdiction, if you show the initiative to do that, which I would strongly encourage, keep in mind that when you're seeing a definition or scope or a case on curtilage, the scope of curtilage that involves Fourth Amendment law, that doesn't mean that in a use of force case, curtilage would be defined to that same scope. Another complicating factor with curtilage in use of force cases is it kind of has to intersect like a Venn diagram with different defense of dwelling, defense of highly defensible property, use of force doctrines. And these different use of force doctrines in defense of property are not the same things. They're different things. So let's take one example, castle doctrine. Now, a proper understanding of castle doctrine simply means that if you would have had a legal duty to retreat safely before using force in self-defense, if you were outside your home, you're relieved of that duty if you're inside your home. So you're attacked by an intruder inside your home. You don't have any legal duty to retreat there, even if you would have had a legal duty to retreat if that same person had attacked you out in the street. That's what castle doctrine means. So curtilage in the context of castle doctrine could well say, well, all right, if you're inside your home, inside the four walls of your home, and you're attacked, you're relieved of any other existing legal duty to retreat before you can defend yourself based on castle doctrine. But what if you're on your front porch? Do you still have the benefit of castle doctrine? Most states say yes, because they say, well, for castle doctrine purposes, you're still within your curtilage. We're going to treat the curtilage as if it were the same as inside the four walls of your home. But not all states do that. Massachusetts, for example, where I lived for 25 years, there is no curtilage for castle doctrine purposes. There's case law in Massachusetts where a defender had 1 foot outside his front door. Wasn't standing a foot outside his front door. Most of his body was inside his home. He extended 1 step outside his front door. No castle doctrine privilege for him. So in Massachusetts, castle doctrine is only inside the four walls of your house. The moment you leave the four walls of your house, you're no longer relieved of that otherwise existing duty to retreat. Most states have a broader view of castle doctrine that'll include some curtilage, but then again, they become ambiguous about how far that curtilage extends. Sometimes they'll say front porch, back porch. Okay, well, that's helpful, but curtilage could extend further. We just don't know how much further. And in a real world sense, the problem for us when we're in the moment acting in self-defense is what qualifies as curtilage for castle doctrine privileges is going to be something that's determined after the fact by other people, mostly by a judge. So we don't know in the moment whether we're standing within our curtilage or not, for the most part. So obviously very hazardous. In terms of other defensive dwelling laws like these, most states have a legal presumption that you had a reasonable fear of imminent deadly force harm if you're defending against a forcible and unlawful intruder in your home. Well, most of those legal presumption statutes, which, by the way, are very powerful statutes, I wish every state had them. If you're defending against a genuine, forcible, unlawful intruder in your home, you ought to have that legal presumption that you were facing an imminent deadly force threat that privileges you to use deadly force in self-defense. I think that's very sound public policy. But by its very nature, those statutes require that you're defending yourself against a forcible and unlawful intruder into your home. Well, if they're in your home, curtilage is off the table. You don't need the doctrine of curtilage. It has no application if the scenario is taking place inside your home. It only has application if the scenario were taking place outside your home. And if it's outside your home, however close to your home it might be, they're not yet inside your home, so the legal presumption statute would not apply. So those are the risks of curtilage, folks. What I would encourage people to do is just pretend you have no curtilage benefit at all, because you won't find out how much curtilage benefit you have until after the fact anyway. So whatever you get after the fact, whatever a judge determines you were privileged to benefit from the concept of curtilage, great, you got a bonus. But the prudent thing to do would be to presume you're not going to get any benefit of curtilage at all. All right, another question that came in from one of our Platinum members asked about quote-unquote self-defense insurance, and he asked why he has a son. His son's 19 years old. His son has, OC spray and keeps a gun in his car, which I presume is lawful where this son lives. Again, I don't do gun law. But apparently at 19, the son cannot yet get a concealed carry permit. So he can't carry a gun on his person, concealed lawfully. He can only keep the gun in his car and have OC spray on his person. And he's apparently tried to go out and get quote-unquote self-defense insurance for all the reasons we talked about in terms of the sponsor of the show, CCW Safe. And apparently 19-year-olds can't get self-defense insurance. Now, I don't know if that's true or not. I haven't researched this, but the person who sent in the question says, hey, my 19-year-old son apparently doesn't qualify for any of these self-defense insurance programs. Why? Why might that be? Now, I can't speak for any of these companies. I don't speak even for CCW Safe, for the sponsor of our program. So for details on any of their policies regarding age of membership, I would encourage you to contact those companies directly. But I can imagine some reasons why they might be disinclined to offer coverage for a 19-year-old. One is often they only want to cover, some of these plans only want to cover people who have a concealed carry permit. And one of the reasons for that is if you have a concealed carry permit, you've at least undergone a state background check. So the people providing the coverage have the benefit of knowing, well, this is a person who's at least passed a state background check, so they're unlikely to be a known miscreant in the community. If you're not old enough to apply for the concealed carry permit, well, then you haven't undergone that background check. You'd be a higher risk candidate for coverage. It may also be a situation where technically the provider of the quote-unquote self-defense insurance could cover a 19-year-old in some states, but not in other states. And as you can imagine, if you're a business serving the United States of America, you'd like to be able to serve all 50 states the same way and not have separate individual policies for each and every state with separate rules for every state. Now, we all know that normal real insurance, like life insurance and car insurance and home insurance, does have different rules in every state and has to accommodate those. But those are generally very large companies. And most of these quote unquote self-defense insurance companies, one, they're not actually insurance companies. They're not selling insurance. And two, they're relatively small. So they probably really don't have the administrative capacity to provide genuinely state-specific plans in each of 50 different states. And finally, another factor might simply be they may consider 19-year-olds, especially 19-year-old men, let's face it, to be a higher risk population than they want to deal with. I mean, if you want to rent a car, last I checked, you had to be at least 25 years old to rent a car. In some states or some hotel chains will only rent to people who are at least 21 years of age. Well, we all know the reasons why. It's because people younger than that are far more likely to get in car accidents or have parties in their hotel room, act in otherwise irresponsible ways. And it's, again, a higher risk population. So that's all speculation on my part. You'd have to contact these quote unquote self-defense insurance policies directly if you want to ask them why they don't cover 19-year-olds, but that would be some of my guesses. Oh, by the way, I will mention in passing that whatever self-defense insurance program any of your 19-year-olds can't register for, or if you're in a state where you can't register for a self-defense insurance type program, keep in mind you can always sign up for our own Law of Self-Defense Platinum Protection Program. Now, this is not a program that pays for all your legal expenses if you're charged in a use of force event, like a CCW safe does, for example. All this does is guarantee my availability and cover my cost, which is thousands of dollars, folks, to consult on your use of force case. But it does apply and is available in every single state. So at least you get the benefit of my guaranteed consultancy on your use of force case. And it doesn't matter if you're in New York or New Jersey or Washington, or if you're under 21 years of age and don't otherwise qualify for a more traditional quote unquote self-defense insurance policy. And you can learn more about our Law of Self-Defense Platinum Protection Program at lawofselfdefense.com/platinum. Okay, let's get to how are we doing for time? 10 minutes left. Here's a question sent in from Stephen by email. And it's a very good question, comes up all the time. And he asks, what qualifies as a use of deadly force? Shooting a gun clearly would qualify as a use of deadly force, but what about pointing a gun? What about drawing a gun to a ready position? What about putting your hand on a gun? What about making the other person aware you have a gun without even displaying it? Hey, I've got a gun, stay back. I'm prepared to defend myself. What about pretending you have a gun, even if you don't? Making the same statement, even though really you don't have a gun, but you put your hand near your waist as if you do to deter them. And Stephen makes a real effort in his home state. He researches some statutes and case law to determine where in his state the courts or the legal system generally might have attempted to set boundaries around this. But I can't have this kind of discussion individually for all 50 states, obviously, in the context of this show. So what I can say is you just don't know where that legal boundary is. Arguably, anything could qualify as a quote-unquote use of deadly force. Now, there are many states that do attempt to differentiate between a use of force and a threat of force. Often a prosecutor considering a case, reading an investigative report about a use of force event, he's trying to decide whether or not to charge, whether or not to go to trial on a case. They will often draw a distinction between a mere threat of force, a hand on a gun to a ready position, and a use of force. But where they draw that line is not legally mandated. They're making a kind of policy decision about where they draw the line. For example, some prosecutors, if all the purported defender has done is draw the gun and keep it at their waist, they treat that case very differently than if the purported defender puts the muzzle on the other person. But that's not a legally mandated boundary line. That's simply a boundary line that prosecutor has chosen to implement in his own good judgment. A different prosecutor in a different jurisdiction might draw that line differently. A different prosecutor in the same office could draw the line differently. That same prosecutor on a different day of the week could draw that line differently. So, and of course, we're all thinking to ourselves, well, we're law-abiding people. We would be acting in self-defense. And there are a lot of states that have these, increasingly, these defensive display laws that say, in effect, that, hey, if someone just displays a gun for purpose of lawful defense, we're not going to consider that a crime. Well, that's awesome, except who says it was a lawful defense? Anytime you'd be arguing in court about your use of force, you're arguing it was lawful self-defense, but somebody else thinks it wasn't. You're at trial because the prosecutor believes it wasn't lawful self-defense, no matter what you're saying about it. So, of course, you're going to say, hey, I only displayed the gun for purposes of the defense. And he's going to say, well, no, you displayed the gun because you were having a bad day, or you're a racist, or you're a Nazi, or whatever he wants to suggest was the unlawful intent behind your display of the gun. It's not automatically acceptable to everybody that it was for defensive purposes simply because you say it was for defensive purposes. So I would not put a lot of weight or hope on these defensive display statutes because, in my opinion, they only benefit you if the prosecutor wants them to benefit you. But if he doesn't, there's no benefit there. He'll simply say you don't qualify for the defensive display statute because your display of the gun was not for defensive purposes. You were angry. You weren't acting in lawful self-defense. So what I encourage people to do is always take the most conservative approach to this, and that is just assume that the moment you make that other person aware that you have a gun for the purpose of changing their conduct, which is what you're doing, right? Stay back, I have a gun. The moment you do that, you've also arguably handed the prosecutor all the building blocks for a narrative of aggravated assault with a weapon. And you better be able to be prepared to defend that display, that communication of your intent, your willingness to use force against another person as lawful self-defense, as consistent with the 5 elements of self-defense, because you may be put to that test in a court. Just because you know it was lawful self-defense doesn't mean the prosecutor's not going to attempt to characterize it as unlawful aggravated assault with a weapon that you need to justify as self-defense, because ag assault with a weapon, folks, is good for 10 to 20 years in most jurisdictions. Felony time. Essentially a good chunk of the rest of your life. So my personal view is I don't want anyone to know that I'm carrying a gun, and I carry a gun for personal protection. In fact, just today I picked up my Colorado brand spanking new, renewed concealed carry permit from our local sheriff's department. Thank you very much, Sheriff. I carry a gun for personal protection. I do every day. I have my entire adult life. But I don't want anyone to know I have that gun unless I need to make loud noises with it, unless I'm compelled to use deadly force in defense of myself or my family or potentially other innocent persons. So if my gun comes out, it's because I believe the circumstances justify my actual use of deadly defensive force. Now, that doesn't mean the gun comes out and I just start shooting. In the time it takes the gun to come out, maybe circumstances change. Maybe the other person sees the gun and runs away or drops their weapon or whatever the case may be. And if the circumstances no longer justify firing, using deadly defensive force, then I expect I won't use deadly defensive force because it's no longer necessary or legally justified. But at the moment I make the decision to bring the gun out, I'm making that decision because the conditions for deadly defensive force have been met. What I'm not doing is presenting the gun without that justification, without the conditions for deadly defensive force being met, and hoping that things are going to turn out right for me, that other people are going to look at that scenario and say, well, he had the best of intentions and he was just warning somebody, and therefore we're not going to put him in prison for the next 20 years. Okay, let's see. Yeah, and by the way, I mentioned earlier Stephen, who sent in this question about what qualifies as a use versus, say, a mere threat of force. He'd done some research. He'd looked at some case law and some statutes, and I encourage all of you to do that. And that can help inform your decision-making on this kind of thing. But keep in mind, there are no guarantees in any of this. The mere fact that there exists precedential law on this issue or any other issue doesn't mean that the next court isn't going to change that precedential law. Appellate courts change the law all the time. That's their role, is to change the law, because they're always dealing with some somewhat different fact pattern than the previous case. They'll simply argue your case can be distinguished from that prior presidential case. Now, we hope that doesn't happen often, but it can happen at any time. So there are no guarantees, even if you're acting based on established precedent. You're in a stronger position. You're less likely to face legal liability, but that likelihood is not zero. There are no guarantees in the legal fight, folks, any more than there are in the physical fight. We can't reduce the risk of losing to zero. That's not possible, unless we're just not in the fight at all. That would be the only way. But once we're engaged in that fight, we can only work to reduce the risk to as close to zero as possible. And we do that both in the physical fight and the legal fight, by ensuring we have the education, training, practice, both tactically and mentally, mental preparation, to mitigate the risk of losing the physical fight and the legal fight as much as possible. Get as close to zero as possible, but the risk is never actually zero. So know that going into any confrontation. All right, folks, I had one more question here I wanted to address, and it had to do with Terry stops. When a police officer can effectively disarm you during a traffic stop, for example, but we're just out of time. I will add it to the list for next week's show, and I promise to cover it in next week's show. I will tell you, if you'd like to read that U.S. Supreme Court decision from, I believe it's 1967, that kind of establishes the constitutional boundaries of this, you can find that decision, Terry v. Ohio, at lawofselfdefense.com/Terry. That's Terry, lawofselfdefense.com/Terry. If you'd like to read that prior to next week's show. But I will address it in next week's show, I promise. It'll be the first question we answer, so we'll definitely cover it there. All right, folks, that's all I have for this week. Again, sorry about not streaming to Facebook. I'll have to have the technology people look into that. In the meantime, remember, if you carry a gun so that you're hard to kill, that's why I carry a gun, so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure that you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense, and stay safe.